Thank you, colleagues. The next item of business is consideration of business motion 24259 in the name of Graham Day on behalf of the Bureau, setting out a timetable for the Stage 3 consideration of the Defamation and Malicious Publication Scotland Bill. Could I call on Graham Day to move the motion?
Move, Presiding Officer.
Thank you very much, Minister. No member has indicated they wish to speak in the motion. The question, therefore, is that motion 24259 be agreed. Are we all agreed? Yes. We are agreed. Thank you. So the next item is consideration of the bill. In dealing with amendments, members should have with them the Defamation and Malicious Publication Scotland Bill at Stage 2, the marshal list, the grouping of amendments. The division bell will sound. Proceedings will be suspended for 5 minutes for the first division, if there is a division this afternoon, and the period of voting for each division will be 1 minute. Members who wish to speak in the debate on any group of amendments should press their request to speak button as I call that group. And members should now turn to the marshalled list. So Group 1, Serious Threshold Test. Can I call Amendment 5 in the name of Andy Whiteman, grouped with Amendments 6 and 7. Andy Whiteman to move Amendment 5 and speak to all the amendments in this group.
Thank you, Presiding Officer. At Stage 1 and Stage 2, I have expressed the view that the serious harm threshold is not justified. I take that view contrary to the view I once held that it was justified. And I take that view as a legislator, considering the evidence that's been presented and in the interests of ensuring that the people of Scotland have a remedy available to them if they feel that their reputation has been harmed. In the committee's Stage 1 report, members recommended, and I quote, that the Scottish Government reviews the evidence we have heard and sets out a clear statement on why the serious harm test is still required. I'm not persuaded that the Minister has done that in her response to the Stage 1 report, nor in response to my amendments at Stage 2. My amendments have the effect of removing the serious harm test in Section 1, and while still maintaining a threshold test for actionability, modify it to actual harm rather than serious harm. And I do this for 2 reasons. First, as I indicated, I do not believe that a threshold of serious harm is justified by the evidence. The serious harm test was introduced to the Defamation Act 2013 in England for reasons that are well known, namely the volume of litigation and the vexatious nature of some of it, and because there was also a muddle in English law as a consequence of the distinct wrongs of slander and libel, a muddle that, as Professor Blackie pointed out in Stage 1 evidence, we do not have in Scotland. The Scottish Law Commission concluded that a threshold was desirable, but it spent very little time considering at what height the bar should be set. My second reason is that the bill introduces at Section 14A a statutory definition of defamation that, and I quote, "A statement about a person is defamatory if it causes harm to the person's reputation, that is, if it tends to lower the person's reputation in the estimation of ordinary persons." So it's defamatory if it causes harm. We've never had this before, relying up until now on the famous Sim versus Stretch test in common law. The Scottish Law Commission never recommended such a statutory definition in its reports or its final draft bill. And therefore, we are in the curious and I would say bizarre position of proposing to enshrine in law a statutory civil wrong while saying in the very same section of the bill that there's nothing that anyone can do about it unless they can demonstrate that the harm is serious. Now, if Parliament agrees that this is a problem, then there's 2 ways of dealing with it. We could amend Section 14A to insert the word serious in front of harm, so as to bring the civil wrong and the actionability thresholds into alignment. Or we could pass my amendments 5, 6 and 7, which retain the statutory definition, but amend the threshold test to one of actual as opposed to serious harm. And thus we would allow everyone who feels that their reputation has indeed been harmed, according to Section 1 and according to the bill we'll pass this evening, to have access to justice, but to have to demonstrate to the court that the harm is or is likely to be actual harm, and not merely presumed, as is the situation today. I move Amendment 5.
Thank you very much, Mr Whiteman. And I call John Finney.
Thank you very much indeed, Presiding Officer. And I wish to speak in support of my colleague Andy Whiteman's comments. And I think when at the outset Mr Whiteman said they should review these positions, I think that's a strength, it's not a weakness, and certainly it's caused me to review the approach. Mr Whiteman's talked about the scrutiny that went on at Stage 1, and I think in the Stage 2 debate he used the term appropriate qualifier. A threshold is needed. I support that it's actual harm rather than serious harm. And the Lachaud case, which has been referred to, and certainly in one of the briefings I have, it says that, and I quote, Scottish courts will treat Lachaud as persuasive authority and follow a similar approach. I certainly find Mr Whiteman's arguments persuasive, and not just in respect of this, but also in respect of creating an offence and then immediately limiting access to it, because there aren't many other remedies. So for all these reasons, I support these amendments in Mr Whiteman's name, and I encourage colleagues to do likewise. Thank you.
Thank you very much, Mr Finney. And can I call Adam Tompkins?
Thank you, Presiding Officer. I've got the greatest of respect for Andy Whiteman's knowledge and experience of the law of defamation, but I'm afraid I don't agree with his arguments that he's put today, which are identical to the arguments that he put at stage 2 when these amendments were either not pressed or defeated if they were pressed. I can't now remember which. And the reason why I don't support his argument is because, don't agree with his argument, is because this bill does something really, really important. It doesn't just modernise the law of defamation and make it fit for purpose. It shifts the balance between the way in which we protect freedom of speech and the way in which we protect the right to protect one's reputation, the right to privacy. And it shifts that balance subtly, but importantly in favour of free speech. And one of the key ways in which it does that is by inserting the serious harm test in section 1. And I would be very reluctant indeed to see that shift go backwards. Anybody who knows anything about defamation law in this country, and as I've already said, Andy Whiteman knows plenty about it, knows that it does not protect freedom of expression sufficiently robustly. And these changes are really important, as was recognised in the evidence at stage 1 that the Justice Committee took on this point. For example, from Scottish Pen evidence that was given by Andrew Tickell, who said that the serious harm test was appropriate in terms of free expression. To give another example, the evidence that the committee took from the NUJ, if harm has been done to someone's reputation, it's in everyone's interest that that is addressed quickly, and having a serious harm threshold will allow clarity at an early stage to ensure that that is done. This has got nothing to do with respect to keeping pace with the law of England and Wales, where this change was made a few years ago. It's got everything to do with ensuring that our Scots law of defamation holds the balance between free expression and protection of the right to reputation correctly. And the serious harm test is a really important part of the way in which this bill, in my judgment, achieves that balance. Thank you, Presiding Officer.
Thank you, Mr Tompkins. And I call on the Minister, Ash Denham.
Thank you, Presiding Officer. These amendments are the same as Amendments 30, 31 and 36 that Andy Whiteman lodged at stage 2 and that were rejected by the committee at that stage. The threshold test of serious harm is an important reform of the current Scots law of defamation, and it is central to rebalancing the law of defamation. Indeed, Scottish Pen described the threshold test as critical to the heart of the bill. And overall, the Scottish Government's view is that where damage to reputation is presumed, as currently happens, the law does not get that balance right. And so the threshold test recommended by the Scottish Law Commission for a number of reasons, and I'm certain that the Commission considered the need for the test and the level at which it was set very carefully. Amendments 5 and 6 would replace the serious harm test with one of actual harm, and this would set the bar too low. It would mean that any evidence of harm, no matter how little, would be enough to meet the test. And these amendments would signal to our courts that this Parliament intends something different from the serious harm test. We would not have clarity on how courts should treat the threshold test of serious harm that has come with the UK Supreme Court's interpretation of Section 1 of the Defamation Act of 2013 in England and Wales. And the result is likely to be a long period of doubt and uncertainty about what the test of actual harm means. And I would point out that this is the exact opposite of what the bill is trying to achieve. It is certain, however, that Andy Whiteman means the level of actual harm to be lower than serious harm. So why should the people of Scotland have less protection for their freedom of expression than people in England and Wales? I will.
Andy Whiteman.
I thank the Minister for giving way. She makes a good point, but I suppose my rejoinder would be that why are we legislating to create a statutory definition about causing harm and then not allowing anyone to take any action if harm has been caused that doesn't meet the serious harm threshold?
Minister.
Because the two things are different. We have the definition, and the serious harm threshold is for actionability. So if someone can prove that they have been harmed, they will be able to take that forward in the court. And I think it is important that if you have been harmed, you should be able to show the court how you have been harmed. So I think for the overall balance of the bill, that this serious harm threshold test is extremely important. So Amendment 6 would have the effect of creating two different thresholds, one for individuals and another for companies and partnerships that trade for profit. And individuals would need to show actual harm and companies would need to show serious financial loss. But not every company is a multinational with an annual turnover in the millions of pounds. And if a company was an individual or a charity, it could easily show actual harm, but instead it must show serious financial loss. So why would the law treat these companies differently? Most companies in Scotland are small or micro enterprises, and for them, reputation will be vitally important. Andy Whiteman also raises a concern about the law defining a harm, but then saying if you haven't been seriously harmed, you cannot pursue a civil remedy. And to that, I would point out to him that the use of thresholds is common in both criminal and civil law to indicate that a particular level of conduct or damage is required before a particular legal remedy or consequence is appropriate. And I'll just give a couple of examples of that. So in Part 2 of the Adoption and Children Scotland Act of 2007, and this concerns making permanent orders whereby paternal rights and responsibilities are vested in a local authority, there is to be a seriously detrimental to the welfare of the child. And then in another example, this Parliament recently considered and agreed to Section 38 of the UK withdrawal from the European Union Continuity Scotland Act of 2021. And this section sets out a serious failure test that must be met in order to raise successful judicial review proceedings in relevant circumstances. And again, setting the threshold is not just an actual failure, but a serious failure. And so that is just a couple of examples, but there are more, Presiding Officer, and it's common for the law to recognise that there may be a wrong, but it does not reach a high enough level to warrant successful court proceedings. And setting the threshold test too low could have serious consequences for freedom of expression. It would not give enough confidence to those who wish to defend their freedom of expression in the face of a defamation action, while making it only slightly more difficult to protect reputation. The crucial importance of freedom of expression justifies this sensible threshold. Andy Whiteman's amendments would nudge the threshold upwards, I believe, only slightly from what we currently have. And in my opinion, that is not high enough. So I would ask the member not to press the amendments 5, 6 and 7. But if he does press them, then I would ask the Chamber to vote with me in opposing them.
Thank you, Minister. And can I call on Andy Whiteman to conclude and wind up in this section?
Thanks, Presiding Officer. I thank those who have contributed to this. I respect Mr Tompkins' arguments about shifting the balance, and I agree with that. Indeed, I agree with the Minister on that point. But in my view, shifting it to actual harm and doing away with the presumption does indeed shift that. With respect, Mr Tompkins did not address my critique of creating a new statutory wrong and in the same section creating a threshold for actionability. And the Minister talked about, for example, adoption legislation. I think it's one thing to, on an ongoing basis, to set various criteria and thresholds for actionability. It's quite another to create a new statutory wrong in a piece of legislation and in the very same section saying that there's nothing you can do about it. My concern in this legislation has been that those who suffer harm, a statutory wrong that we'll be passing tonight, probably, do not have a remedy available to them, and that causes me a problem. But nevertheless, I understand the arguments being put at stage 1, 2 and 3, and don't anticipate this will be getting much further, but at least Presiding Officer have managed to put the arguments on the record and Parliament will be able to test them. Thanks.
Can I assume from that, Mr Whiteman, that you're pressing to a vote?
Yes, I'm pressing Amendment 5.
Thank you very much, colleagues. So the question is that Amendment 5 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a division. Members will need to access the voting app, so I'm going to suspend Parliament for 5 minutes to call some members to the chamber and the others to access the voting app. 5 minutes suspension. Last reminder, colleagues, the pin for today is 7566, and we will be switching broadcasting back on shortly. 7566. Thank you, colleagues. We are now back in session. So we're going to move straight to the vote. The question is that Amendment 5 be agreed to. Are we all agreed? No. We're not agreed. We'll move to the vote. Members, please press their buttons now. This will be a 1-minute division on Amendment 5. That vote is now closed. Please let me know if you were not able to vote. Thank you. The result of the vote on amendment number 5 in the name of Andy Whiteman is yes 32, no 86. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 6 in the name of Andy Whiteman? Andy Whiteman to move or not move? That is not moved. I'm turning now to Group 2. This is on secondary publication regulation making power. Can I call Amendment 1 in the name of Liam Kerr in a group on its own? Liam Kerr to move and speak to Amendment 1.
Yeah, thank you, Presiding Officer. Colleagues will recall that this was an amendment that I brought forward at stage 2, which sought to limit the delegated powers of ministers to technical amendments whilst allowing flexibility to modernise the law in line with technological developments. Now, to explain what I mean by that, Section 3.6 enables the Scottish ministers to make regulations modifying subsections 3 or 4 to add, alter or remove activities or methods of disseminating or processing material which can be undertaken by a person without being classified as an author, editor or publisher, or, in the case of an employee or agent of such a person, being responsible for its content and the decision to publish it. Now, the underlying purpose here is to restrict the regulation-making power in subsection 6 so it can only be used in consequence of technological developments. Now, at stage 2 in debate, it was felt that such power would be too restrictive, so I didn't press it, pending discussion with the Minister and her officials to ensure any amendment captured the policy intention more accurately. I'm very grateful to the Minister and her officials for their assistance in this regard. My redrafted amendment therefore permits regulations to be made only where Scottish ministers consider it appropriate to take account of 2 different situations. The first reflects technological developments, including where certain technologies cease to be used, relating to the dissemination or processing of materials. The second reflects changes in how material is disseminated or processed as a result of such developments. Any such regulations are to be subject to the affirmative procedure, and stakeholders therefore will have an opportunity to express their views on any proposed change, and ultimately Parliament will decide whether a proposed change is appropriate. Presiding Officer, I believe this is a good amendment and I seek Parliament's support for it. Thank you.
Thank you very much, Mr Kerr. I don't have any other indication that members wish to contribute. Minister.
Sir, someone who is not the author, editor or primary publisher of a defamatory statement should not be liable for it, except to the extent that they are responsible for a statement's content or the decision to publish it. So Section 3 gives effect to this purpose and limits the circumstances in which a defamation action can be brought against a secondary publisher. And Scottish ministers are given regulation-making powers to adjust the subsections which lay out the activities which a person can carry out without being classed as an author, editor or publisher. And the Scottish Government made clear in its Delegated Powers Memorandum that the reason for taking this power is to ensure that the provision is future-proofed to deal with any technological changes. Any regulation-making power should not be too expansive, particularly as any regulations made by Scottish ministers in connection with this section will have a significant impact on freedom of expression. So this amendment will make sure that the power of Scottish ministers is not too wide, that it will unduly restrict freedom of expression without Parliament's consent, but also wide enough to allow Scottish ministers to account for any necessary changes. And it's worth remembering that any proposed regulations are to be put out to consultation and they are subject to the affirmative procedure. So stakeholders will have an opportunity to express their views on any proposed change, and ultimately it will be for the Scottish Parliament to decide whether a proposed change is appropriate. And it's my view that this amendment achieves the proper balance between making sure that those who need the protections of this section are given it in good time, and the need to make sure that powers of Scottish ministers to restrict freedom of expression are not unnecessarily wide. So I'm grateful to Liam Kerr for agreeing to work with the Scottish Government to prepare this amendment, and I would encourage members to join with me in supporting it.
Thank you. Does Mr Kerr wish to add any further comment?
But I will press the amendment.
Thank you very much. So the question is, the Amendment 1 be agreed to? Are we all agreed? Yes. We are agreed. Can I call Amendment 7, Andy Whiteman, to move or not move?
Not moved.
Not moved, thank you. Can I turn now to Group 3? This is on the powers of the Court. Can I call Amendment 8 in the name of Fulton McGregor, grouped with Amendment 9? Fulton McGregor to move Amendment 8 and speak to both amendments in the group.
Thank you, Presiding Officer. I move Amendments 8 and 9 in my name. These are amendments that follow on from a previous amendment that I lodged at Stage 2. I'd like to start by placing on record my thanks to the Minister for her commitment to work with me ahead of today. The aim of these amendments is to achieve a proportionate balance between the protection of reputation, the right to freedom of expression and the power of the court to make orders to the operator of a website in the early stages of defamation proceedings. Section 30 is intended to provide for the fact that it may not always be possible for the author of material which is subject to of defamation proceedings or proceedings under Part 2 for a malicious publication, prevent further distribution of the material or orchestrate its removal. To address that, subsection 1 currently empowers the court to order the removal of material which is subject of defamation or malicious publication proceedings from any website on which it appears, as well as to order a person who was not the author, editor or publisher of the material stop distributing, selling or exhibiting material containing the statement. Section 30 in the bill, as it currently stands, would allow a court to order the operator of a website to remove the statement which is the subject of a complaint. Where a court has had the chance to consider the argument from both sides and come to a full conclusion, the order to remove a statement that has been found to be defamatory is an entirely reasonable one. However, in the explanatory notes for the bill, it is explained that this power is not confined to circumstances in which the final outcome of proceedings has already been determined by court. Accordingly, the court would be entitled in an appropriate case to grant an order for a removal or cessation of distribution on an interim basis before the final outcome of the proceedings is known. The power of the court to order removal before a full decision has taken place seems unnecessary, given other alternative measures which this amendment seeks to introduce. In evidence sessions of the Justice Committee, concerns were raised by media groups including the Society of Authors, Scottish Pen, the BBC and the Ferret through legal academics, and from civil society organisations like Scottish Pen and the Open Rights Group. And I'd like to thank all of these organisations, and particularly Matthew Rice from the Open Rights Group, for their input in the development of these amendments. So in seeking a proportionate balance in these early stages of the defamation dispute in the court system, this amendment proposes to amend Section 30 by introducing a court power to order the website operator to include in the website a prominent notice that the statement is subject to the proceedings. This notice must be in a place or forum that ensures that a person accessing the statement is made aware of the notice every time that they access the statement. I should make it clear that this amendment seeks to leave intact the power of the court to order operators to order the operator by interdict to remove the statement at the end of the proceedings. It is focused primarily on when the proceedings are ongoing, and this power would be appropriate to be exercised. Additionally, nothing in this amendment prevents the website operator from removing the statement complained of themselves, which they are entitled to do throughout any potential defamation dispute. I believe the addition of a notice power for the court meets the policy objectives of the bill to strike an appropriate balance between freedom of expression and protection of reputation, clarifies the law and improves its accessibility. And I move the amendment. Thank you.
Thank you very much, Mr McGregor. And can I call on John Finney?
Thank you very much indeed, President Officer. Mr McGregor mentions the Open Rights Society, and I commend a lot of their work. And indeed, it was via that route that I was lobbied by a constituent concerned, and I quote here that as things stood, you were guilty and until proven innocent. And I can commend the words that they went on to say about Mr McGregor's amendment, that these safeguards will better balance the right of freedom of expression online with the need to fairly protect reputation. And for these reasons, I hope others will join in supporting Mr McGregor's very worthy amendments. Thank you.
Thank you, Mr Finney. And can I call on the Minister, Ash Denham?
So an important feature of this bill is the range of new powers given to courts that will help repair unfair damage done to an individual's reputation. Ordinarily, a court would have awarded damages, but if this Parliament agrees, a court will be able to allow a statement to be read in court, order a summary of its judgment to be published, and order the removal of material from a website. Section 30 grants courts the power to order the removal of material which is the subject of defamation or Part 2 proceedings from any website on which it appears. And this is an effective remedy that will, in relevant circumstances, help to prevent ongoing unfair damage to an individual's reputation. A similar power has been conferred on courts in England and Wales by the Defamation Act of 2013, and the bill before us today seeks to grant Scottish courts the same. There may, however, be situations where a court decides that removing a statement altogether does not properly balance the rights of protection of reputation and freedom of expression. It could be that the proper balance favours continued publication of the statement complained of, but with a notice affixed to it that lets those accessing it know that it is subject to defamation or malicious publication proceedings. For example, this could be where proceedings are ongoing and a court has not yet made a final determination. The notice permitted by this amendment would be attached on the website to the statement complained of, and it must be prominent. This means it cannot be hidden away on some other web page or set out in tiny print, and therefore easily overlooked by users viewing the allegedly defamatory statement. It must also be visible to each individual user every time they access the statement, for so long as the proceedings are ongoing or such other time period ordered by the court. The amendment lodged by Fulton McGregor will make all this clear, and should a court decide to use this power. It is another remedy that the court can use to assist in restoring a person's unfairly damaged reputation, and is added to others that the Scottish Government have introduced. And having it on the face of the bill means that an individual knows that this is one of a number of remedies they can seek from a court in order to protect and restore their damaged reputation. And I hope members will join me in supporting this amendment.
Thank you, Minister. And can I call, does Mr McGregor wish to add any comments by way of winding up?
Thank you, Presiding Officer. I'd just like to simply end by thanking the Minister and her officials again. The amendment lodged before members today isn't changed substantially from that was at stage 2, but by working with the Minister and officials, perhaps we've been able to find more balance and perhaps alleviate any slight concerns that there were at stage 2. So I thank the Minister again, and yes, press the amendment in my name.
Thank you very much. So the question is that Amendment 8 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 9, Fulton McGregor, to move or not move?
Moved.
That is moved. The question is that Amendment 9 be agreed to. Are we all agreed? Yes. We are all agreed. We're going to turn now to Group 4. This is on EU exit technical amendments. Can I call Amendment 2 in the name of the Minister, group with Amendment 4, Minister to move Amendment 2 and speak to both amendments?
Thank you, Presiding Officer. These are technical amendments arising out of the UK's departure from the European Union. And Amendment 2 in my name removes a reference to Section 19F of the Prescription and Limitation Scotland Act of 1973. And that section was recently repealed by regulations that have now come into effect following the end of the transition period after the UK left the EU. As for Amendment 4, a statement which is false and defamatory is presumed to be made with malice, and that presumption is rebutted if the statement is subject to qualified privilege. In the event of qualified privilege attaching, it is for the pursuer to pursue malice. Qualified privilege arises both at common law and under statute, and Schedule 1 lists a number of communications which are privileged. One such communication, however, refers to another member state. And as the UK is no longer a member of the EU, this amendment will rectify this. The amendment will maintain the current position under the law, and no restriction of freedom of expression should result. So I move Amendment 2 and ask members to support both the amendments that are in this group.
Thank you, Minister. And no member appears to have indicated they wish to speak, so we'll go straight to the question. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. We are agreed. Turn now to Group 5. This is on the interruption of limitation period, media complaints and expert determination. Can I call Amendment 3 in the name of Liam Kerr in a group on its own? Liam Kerr to move and speak to Amendment 3.
Thank you, Presiding Officer. It's another amendment which I brought but didn't press at Stage 2, but has been revised and improved for Stage 3. Section 33 currently makes provision for mediation, which is helpful and will pause limitation during that period. Now, several witnesses felt that this ought to be extended to other forms of dispute resolution, such as arbitration, expert determination, maybe press complaints or ombudsman bodies. So this Amendment 3 provides that the limitation period of 1 year will not run during any period of time that parties engage in certain forms of alternative dispute resolution. These alternative methods are expert determination and a complaints process, such as press complaints or ombudsman complaints, which will be reflected, I understand, in the explanatory notes. So this is going to be achieved by the insertion of a new section into the bill. As part of the new section, I seek to define the two processes in subsection 4. Subsection 2 sets out to provide clarity as to when parties enter and exit such a dispute resolution process. Now, given that these processes are not necessarily structured or formal and the press complaints bodies are not defined in statute and so liable to change without providing a means to update the Act short of primary legislation, subsection 5 grants the Scottish Ministers power to amend the definitions found in subsection 4 to respond to future changes in the processes or types of bodies that handle media complaints. Any regulations made by Scottish Ministers are to be subject to the affirmative procedure as according to subsection 6. Now again, this amendment has benefited from the advice and assistance of the Minister and officials, for which I'm grateful, and I would be grateful similarly to earlier for Parliament's support. Thank you.
Thank you very much, Mr Kerr. No other member has indicated they wish to speak. Can I call the Minister, Ash Denham?
A number of members of this Parliament have, over a number of years, taken a keen interest in the methods of dispute resolution that don't involve a court. And the bill, as introduced, made provision for mediation in Section 33, and Mr Kerr's amendments extend the coverage of alternative methods of dispute resolution to include expert determination and media complaint processes. Now, given the nature of defamation, alternative forms of dispute resolution can be especially useful for resolving disputes, whether this is by way of mediation, arbitration, formal complaints processes or expert determination. And it seems only right that parties are not penalised for seeking to repair unfair damage without resorting to a court. And it also seems right that we give those same parties the time to pursue these options without the threat of time running out for raising court proceedings in actions of defamation and malicious publication. There is no need to force a party to lodge court proceedings in order to protect their legal rights solely because they are looking for other means to resolve a dispute. So I am grateful to Mr Kerr for agreeing to work with the Scottish Government on the definitions and drafting, and I believe that we have a robust provision that extends the ways that a defamation or a malicious publication dispute can be resolved without the same expense and weight involved in a court process. I'll be supporting this amendment, and I hope that members will join me.
Thank you very much, Minister. Does Mr Kerr wish to add anything?
Nothing to add other than to press the amendment.
Thank you very much, Mr Kerr. So we'll go straight to the vote. The question is that Amendment 3 be agreed to. Are we all agreed? Yes. We are agreed. The last question is that Amendment 4 be agreed to. Are we all agreed? Yes. We are agreed. And that ends consideration of amendments. Now, as members will be aware, at this point in proceedings, I am required under standing orders to decide whether or not, in my view, any provision of the bill relates to a protected subject matter. That is, whether it modifies the electoral system or franchise for Scottish parliamentary elections. In the case of this bill, in my view, it does no such thing. Therefore, it does not require a supermajority to be passed at stage 3. So we're going to move shortly on to the debate, but we're just going to have a short pause before we do so. A short pause before we move on to the debate on the bill.
Thank you very much. The next item of business is indeed a debate on motion 24257 in the name of Ash Denham on the Defamation and Malicious Publication Scotland Bill. Can I invite members who wish to speak in this debate to press the request to speak buttons now, and I call on Ash Denham to speak to and move the motion.
Thank you, Presiding Officer. I'm pleased to be here today to open the debate on the Defamation and Malicious Publication Scotland Bill. And I'd like to begin by thanking members of the Justice Committee and its clerks for their work on the bill. The bill is largely the outcome of work undertaken by the Scottish Law Commission, and it takes forward every substantive recommendation that it made. And I would like to thank the Commission for its valuable work on this. It's been mentioned here already today, but it's important to reiterate why the law of defamation is significant. And the law deals with two competing fundamental human rights: freedom of expression and protection of reputation. And we as lawmakers have to find an appropriate balance between the two, and I believe that the bill gets this balance right. Overall, the aim has been to make sure that our law of defamation is fit for the 21st century, with a clear and accessible framework that balances these two rights. The bill updates defamation law and simplifies it in some key areas, replacing and restating the existing law. One important reform is that before a successful defamation action can be raised, a damaging statement must be published to someone other than the person who is the subject of it. Defamation law should be about protecting reputation, but as the law currently stands, it protects more than this. If we are to say that freedom of expression is to be restricted in order to protect reputation, then it's vital to make sure that defamation law is not overextended to protect other interests. The threshold test of serious harm has been greatly discussed at all stages as this bill has progressed through the Parliament, and this test will give much needed confidence to those who have been told that they have published a defamatory statement. Scottish Pen described the threshold test as critical to the heart of the bill, that courts should not be asked to settle defamation litigation where there is little or no harm caused to individual reputation. The consequences for freedom of expression in such a situation should not be underestimated. Section 2 of the bill places on a statutory footing the common law principle that public authorities cannot raise defamation litigation. A public authority should use the ballot box to protect its reputation, not defamation law. There has been no decided case on whether the principle applies in Scotland, although legal professionals work on the assumption that it does. And this section, if Parliament agrees, puts that beyond doubt. The approach taken on secondary publishers will help to make sure that defamation law is focused on the source of a defamatory statement. Under the present law, secondary publishers are not actively responsible for the content they host, but they can be held liable. And we have heard how this liability can lead to secondary publishers taking a cautious approach to content. The law as it stands encourages secondary publishers to remove content, thereby interfering in the exercise of an individual's free expression. Ultimately, this should be a matter for the court to determine and not secondary publishers. Another significant aspect of the bill is that it brings together the main defences to a defamation action. The Scottish Government has taken this opportunity to reform the defences where necessary. For instance, the defence of honest opinion. One innovative change has been to extend the need to show that facts underpinning the opinion to be either true, privileged, or reasonably believed to be true. Having the defences of truth, honest opinion, and publication on the matter of public interest all set out in one place will help defenders better understand the law rather than leaving the defences uncodified. In a defamation action, the usual remedy sought and granted by a court is an award of damages. But this bill will widen the range of remedies available to those whose reputation has been unfairly damaged. A pursuer will be able to ask a court to remove or to affix a notice to a defamatory statement, ask to make a statement in court, or ask that a summary of the court's judgment is published. Ultimately, for most, the purpose of a defamation court action is to vindicate unfairly damaged reputation, and having new types of remedy that can achieve this is a welcome reform. And finally, I'd like to briefly mention the equally important reforms to the law of malicious publication brought about by this bill. The Scottish Law Commission gave a great deal of consideration to the common law actions of verbal injury and the new statutory cause of action of malicious publication, which replaces it. The law treats malicious publication actions differently from actions on defamation. In a malicious publication, the law does not presume that the statement complained about is one of fact, that it is false, or even that it was made with malice. Each of these elements must be proved by the pursuer, and in particular, the test of malice has been strengthened as the bill progressed, and I'd like to thank the Justice Committee for its work on this. In the end, malicious publication actions fill a gap in the law that would be left open if defamation was left as the only actionable form of wrong. The law of defamation in Scotland is due for reform. The last substantive changes were made more than a generation ago, and it's no longer fit for purpose. But any reform must find a balance between the two competing rights at the centre of any defamation action: the right to protection of reputation and the right to freedom of expression. And I believe that this bill achieves a more appropriate balance. Throughout the bill process, I've listened to the views of others across the chamber. There have been a number of amendments that the Scottish Government have either made in response to concerns or else supported after collaborative work with individual MSPs. And if agreed to by this Parliament, the reforms brought about by this bill will modernise and simplify our laws of defamation and malicious publication. So, Presiding Officer, I move that the Parliament agrees that the Defamation and Malicious Publication Scotland Bill be passed.
Thank you very much, Minister. And I now call on Liam Kerr.
Thank you, Presiding Officer. I said during the Stage 1 debate into this bill that large parts of my week at the moment are set aside for reading, questioning and commenting on freedom of speech. Now, that hasn't changed since that debate, and indeed nor should it, as of course freedom of expression is and remains one of our most important fundamental rights with which we interfere at our peril. In these times when technological developments and social media have allowed pretty much anyone to be a publisher, it is imperative both that free speech is protected and any threats caused to it by laws are avoided. However, as this bill acknowledges, there is also the perhaps sometimes competing right to protect one's reputation. And it is striking the balance between these two rights that this bill seeks to achieve. Now, there is no doubt that striking that balance is not straightforward, which is something the Scottish Law Commission recognised as they sought to put Scots law of defamation on a statutory footing fit for the 21st century. As the Minister set out, this bill seeks to implement the substantive recommendations of the SLC's report, particularly insofar as it recommended changes to the common law rules for verbal injury, a change in the presumption for trial by jury for defamation cases, and that public authorities should not be able to initiate defamation proceedings. Many more recommendations were made and appear in the Defamation Bill. It is the view of the Scottish Conservatives that the Defamation and Malicious Publications Bill broadly achieves the balance required, and therefore will vote in favour at decision time tonight. Now, whilst that balance is achieved, as Adam Tompkins said earlier, I think it's fair to say it does shift the balance towards freedom of speech, insofar as it introduces a serious harm to the pursuer's reputation test. That is to say, for a defamation action to succeed, a pursuer will have to show not merely harm, but serious harm to their reputation. And there's been a very interesting debate around this test, and it's possibly the most contentious aspect of this bill. The test was introduced, according to the policy memorandum, which itself picks up on the Scottish Law Commission's work, because of a lack of authority in Scots common law and the inability of Scottish courts to dispose of trivial claims at an early stage. It also brings Scots law into line with the position in England and Wales, leading some in the committee's evidence-taking to suggest this is an English solution to an English problem. Now, I find these arguments interesting because it does seem to me that if there's a lack of authority, then arguably the Law Society have a point, that if an extra hurdle is brought in, it could deter claims and thus lead to even less such authority developing. And whilst ensuring the ability to dispose of trivial claims feels like the right thing to do, the Faculty of Advocates suggested that there is no reason to think that Scottish courts have thus far been troubled by such trivial claims. But I listened carefully to the media respondents in particular, who said that a serious harm test adds clarity, prevents cases without merit going forward, and crucially, gives them reassurance in publication to avoid a chilling effect. And it's this final point which I find particularly persuasive. So whilst I see merit in both sides of the debate, and I'm pleased that all views have been heard and considered, on balance I align with the committee's view, and I think the Parliament's view, which was to favour retention of the serious harm test. Now, I was also exercised somewhat by the sections on malicious publication, which I felt throughout hadn't been given quite the same level of attention as perhaps others were. I was concerned principally about the definition of malice, the applicability of defences, and a de minimis level of damage akin to the serious harm test. And I've been satisfied on all of those, with the Minister acknowledging my concerns and either working with me to amend the definition to ensure that any statement must be both false and malicious to be defamatory, or she and her officials engaging in challenging yet constructive debate with me on the merits or otherwise of my amendments. On that point, incidentally, I do think it right and proper to acknowledge the Minister and her officials' approach to this bill, because at least when dealing with me, certainly this has been respectful, constructive and productive throughout. Now, I did have other concerns, principally around limitation and observing other colleagues' challenges, but I can see that concerns raised with stakeholders have been, for the most part, addressed either at stage 2 or earlier today. Indeed, on that limitation concern, I am content that my amendment was passed earlier today, ensuring that not only will mediation stop the clock, but other specific forms of conciliation could do so. For which reason, it is my view that this bill strikes the right balance between freedom of expression and protection of individual reputations. And accordingly, the Scottish Conservatives will vote to pass the bill at decision time tonight. Thank you.
Thank you very much. I now call on Neil Bibby to be followed by John Finney.
Thank you, Presiding Officer. I'd like to start by taking this opportunity to thank the Scottish Law Commission for all the work they have done on this bill. And I also like to pay tribute to the members of the Justice Committee for all their scrutiny on the bill too, to ensure that defamation law in Scotland is fit for the 21st century. As all members this afternoon have said this afternoon, it is important that with this legislation we strike the proper balance between the freedom of expression and the protection of one's reputation, something that hasn't always been the case in Scotland's defamation laws. By modernising defamation law and placing it on statute rather than relying on common law, we ensure that the law is accessible and that the requirements on an individual's speech with regards to defamation are made clear. However, by placing the definition of defamation on statute, we must ensure that the ability of the courts to continue to develop the law through case law is not stifled. And of course, in this digital age with more and more publications online, technology and communication methods will continue to evolve and develop, and so must defamation law too, to ensure it remains fit for purpose. I welcome the assurances that have been given by the Scottish Government to address this and the other changes the Minister has made to address other concerns and issues throughout the passage of the bill. I'm aware that there has been much discussion throughout the course of this bill on the introduction of the serious harm test, which is a significant change to the current law on defamation, but one which is similar to the change in legislation in England and Wales in the 2013 Act. As I said previously, we do need to ensure that we strike the proper balance between freedom of expression and the protection of one's reputation. As it stands, current defamation laws can have a chilling effect on media scrutiny and freedom of speech, as those with sufficient resources can bring vexatious cases and make litigation threats. We do need to prevent vexatious cases being brought forward. However, I recognise concerns that the serious harm test takes us past that point. The amendments put forward by Andy Whiteman to counteract the chilling effect were unsuccessful, but for the record, Scottish Labour did support those amendments. This legislation also codifies the Derbyshire principle onto the statute, whereby public bodies cannot bring defamation actions, and I noted that in stage 2, further clarity was added to the bill on what bodies would be caught under the definition of a public authority. Scottish Labour, however, believe that this did not go far enough and are disappointed that proposals to bring private and charitable organisations who deliver public services should be included within the Derbyshire principles that were not supported by the Government or the Justice Committee. In such cases, it is vital that the public interest defence be rigorously applied to ensure that this does not add to the chilling effect in discussions or criticism public activities being administered by private bodies. Scottish Labour also believe that actions available to the courts prior to a case being decided must be proportionate. That is why we supported the amendments from Fulton McGregor, which removed the powers afforded by this bill for courts to order that material subject to legal proceedings be removed. This would instead be replaced with the ability to attach a prominent notice to such materials or publications identifying that is a subject to legal action. Presiding Officer, in closing, this bill is necessary to modernise Scotland's defamation laws and make them fit for purpose. This bill can also rebalance the law to limit the chilling effect and promote freedom of expression. Scottish Labour can and will therefore support this bill at decision time. Thank you.
Thank you very much. And I call on John Finney to be followed by Liam MacArthur.
Thank you very much indeed, Presiding Officer. And at this stage, it's appropriate that I join others in thanking those who have brought us to this point. The Scottish Law Commission, and we've heard that every one of their substantive recommendations was taken forward, and the Justice Committee met with them, and can I thank them for their work, not just in this, but in relation to other matters too. Can also give a personal thanks to the Minister and her officials. The manner of engagement, which others have referred to, I can personally vouch for. I had meetings with the Minister along with Mr Whiteman, and whilst our meetings didn't quite bring the result that others have, differing views were genuinely held, and I thank the Minister for the way she's gone about that, and it's evident that it's quite. And also thank the committee and parliamentary staff who worked tirelessly for us, and the witnesses both in person and in writing, and indeed all those who provided briefings. I don't think anyone would dispute that this legislation has had detailed scrutiny. We've had some very good debate. and everyone entered it with the same goal, and that was to make good legislation. I reflect on the SPICE briefing, which was one of the initial papers we had, and the pivotal issue that's been referred throughout this and will continue to be the balancing of rights. And there was a note in there that I thought it was worthy of repeating, and that was, and I quote here, Scots law was grappling with issues around freedom of expression, individual privacy and protection of reputation well before human rights came into the frame. However, the requirement to uphold the rights contained in the European Convention on Human Rights brought an additional dimension into this balancing act. And of course, we know, presiding officer, that we can only pass legislation that's compatible with the Convention. And like many things, and most legislation, this has been about striking this balance between competing factors. The appropriate balance between the right to freedom of expression contained in Article 10 and the right to respect private life in Article 8. And it's the conclusion of the Scottish Green Party that balance has been struck, and for that reason we will be supporting the legislation at decision time tonight. Now, the balance, that particular balance, is not unique to this bill. The Justice Committee is presently wrestling with the reality of reflecting both these important rights, freedom of expression and the right to respect for private life, in the hate crime bill, where both these issues are starkly at play. And we read the quote, the right to freedom of expression protects the right to hold and exchange information and opinions. And to state the obvious, this isn't new law. This is moving to a statutory definition, clarifying the law, because as one of our briefings said, much of the current law is obscure and based on judges' decisions in previous cases. So the bill aims to make the law easier to understand. We'll see with that. A lot of people have difficulty with understanding the law. Strengthens existing defences and in relation to publication in the public interest. Now, we debated again thresholds today and the change from there being in the bill from being no express harm threshold in the law to a serious harm to reputation being needed. And I think it's worthy of noting that the Law Society, perhaps for different reasons from myself, continue to have reservations about that element. And it's also very clear that much of law is opinion, even emphasis and perceptions rather than fact. And we saw that in discussions around Mr. Whiteman's amendment. And I say again, differing views genuinely held. Another parallel with the hate crime bill is the issue of the potential chilling effect. And the consensus the committee had, the bill alters the balance of freedom of speech. It alters the balance of this debate in favour of freedom of speech. And I think that's important in a vibrant democracy. The common law largely focused on print publications, and some rules don't readily transfer. So I think we saw a very good amendment from Mr. Kerr covering that, future-proofing, that much-used phrase, both in terms of how information is processed, and I think importantly acknowledging that these could be important decisions worthy of the widest possible discussion, and therefore putting it on the affirmative procedure. The comment that the statement complained of must have been published to a person rather than simply the one who's subject to the statement, that is an improvement, and that's to be welcomed. I think there are a number of important features in this that are to be welcomed. The Minister will know that I rambled long and hard about the Derbyshire principle and my concerns that with so many of our public services delivered by private organisations, that we don't have a level playing field. We don't have that. We don't have that in relation to the huge sums of money that go out in respect of ferry services, CalMac, the public provider, versus Serco, and the time frame, because one of the elements was delivering services from time to time. Well, when you're talking about a 15-year contract, where is the political accountability in that? And importantly, I want to point out that the Court of Session held that Serco, which had been contracted to provide housing to asylum seekers, was not a public authority. I commend references to alternative dispute resolution. I think it's very important. We've spent a lot of time putting laws in place. In an ideal world, we don't want to see them put into practice. We want people to find other methods of doing that. So references to alternative dispute resolution, in my mind, are always welcome. Can I thank the Minister for engagement? Can I thank colleagues for working on this? I think we've got a good piece of legislation. And as I said previously, at decision time tonight, the Green Party will be supporting. Thank you.
Thank you very much. And I call Liam MacArthur.
Thank you very much. Can I start by warmly welcoming Neil Bibby to his new role? I don't know whether we could look forward to seeing him at the next and probably the last Justice Committee meeting of this session, but I wish him well in his new role. Deputy Presiding Officer, as well as confirming Scottish Liberal Democrat support for this bill, can I add my thanks to all those who helped the Justice Committee in our scrutiny of it, and in particular, I think, as others have said, the Scottish Law Commission, who I think bear greatest responsibility for development of these proposals. This is a very technical area of the law, showing an area which isn't, but one that was overdue for updating and codifying, not least to help make it more accessible to those who might have reason to use it. Even though the government's intention was to update and codify, however, as others have observed, the government's also taken the opportunity to reset the balance, however modestly, between protecting reputation on the one hand and freedom of speech on the other. By her own admission, the Minister recognised that the scales are being tipped slightly more in favour of freedom of speech. We had calls and evidence for more radical moves in that direction from witnesses concerned about the so-called chilling effect caused by legal threats from those with so-called thin skins and thick wallets. On the other side, there were appeals against what was seen as an erosion of privacy rights in an attempt to impose English solutions to an English problem in terms of defamation. As I said at stage one, however, I think the government has broadly got the balance right, though on a personal level, I'm very grateful to Andy Whiteman for his contribution on the question of the serious harm threshold. Having lived experience of the law of defamation, Mr Whiteman's insights were both interesting and helpful, even if ultimately his argument for setting the threshold and actual harm proved unsuccessful earlier on this afternoon. The bill sensibly includes a statutory definition of defamation as well as a codification of potential defences, both of which are welcome developments that should aid accessibility. However, as the committee rightly made clear, it will be important that these and other relevant aspects of the bill allow sufficient flexibility to adapt over time and draw on case law. The committee also called for greater clarity around the way in which the Derbyshire principle was expressed, referred to there by John Finney, and it remains to be seen whether the bill was far enough in this regard. But I appreciate that some of the options considered by the committee could well have been unduly arbitrary and led to unintended and unwelcome consequences. Exclusion of secondary publishers from liability is another element of the bill worthy of support. And while I think we're right to resist attempts to amend the bill to allow effectively take-down notices prior to any evidence being heard, hopefully the modest changes agreed today, making clear that a statement is subject to proceedings, offer some reassurance and additional clarity. Finally, on the question of limitation, the reduction to 1 year for bringing a case is the right move, particularly in a digital age. While there will be instances where the court will be able still to exercise discretion, and mediation or other forms of dispute resolution can and should be encouraged, again, as John Finney rightly pointed out, this change to limitation should help address another area where chilling occurs through the mere threat of legal action. Deputy Presiding Officer, this bill will be judged on the basis of its success in striking an appropriate balance between the rights of protecting reputation and freedom of expression. I believe it gets that balance just about right. I commend the Minister and our officials for the way that they've gone about engaging with the committee and stakeholders on this bill. And on that basis, Scottish Liberal Democrats will be supporting it at decision time shortly. Thank you.
Thank you very much. And we now call the one speaker in the open debate, Rona Mackay.
Thank you, Presiding Officer. The Defamation and Malicious Publication Scotland Bill, which will hopefully be passed today, is absolutely vital to ensure that the law of defamation is fit for 21st century Scotland. Can I thank the Scottish Law Commission, all our witnesses who gave evidence, and the excellent clerking and bill team who managed to make a somewhat technical bill more easy to understand for members of the Justice Committee. Presiding Officer, today's fast-changing and wide-ranging methods of communication demand a clear and accessible framework that more appropriately balances the protection of individual reputation and freedom of expression. Throughout our scrutiny of the bill, we heard that complex and costly defamation litigation can lead to a chilling effect on freedom of expression, whereby people are discouraged from publishing because they fear the threat of legal action. The widespread use of social media, blog posts and so-called citizen journalists means that defamation law doesn't just affect big media companies. It's become easier to spread unsubstantiated rumours or to deliberately damage someone's reputation. And this has put website operators on the front line of the battle over freedom of expression. We took evidence from individuals, media companies, legal stakeholders and content creators who were extremely helpful in outlining their experience of defamation law. There's no doubt that the existing law is patchy, goes back decades and doesn't strike the right balance between freedom of speech and protection of reputation, particularly with regard to online publication. The most recent legislative changes occurred in 2013 and before that in 1996. Presiding Officer, like others, can I thank the Minister for working collaboratively with all committee members and stakeholders to reach consensus on this bill. There were some areas of contention raised during evidence sessions, particularly in relation to public defences, raising the threshold for bringing defamation actions, the serious harm test, single publication rule and a one-year time limit to raising court action. The amendments passed today should give confidence to publishers that only cases where real harm has been done to an individual's reputation will litigation be allowed to proceed in our courts. Presiding Officer, it's vital to take account of the changing landscape in publishing. Traditional journalists, which I was one, undergo training and editors have access to legal advice, but this is rarely the case for those publishing online. Defamation law has been developed with a focus in print publications, and some of the rules are difficult to adapt to online publication. The bill seeks to address concerns in that area by increasing protection to internet intermediaries who are secondary publishers. The bill makes provision for the courts to require a website to remove content and to require other people or bodies to stop distributing or showing material. And my colleague Fulton McGregor's amendments are very helpful in this area. Presiding Officer, it's impossible to fully future-proof the law in this area due to the ever-changing nature of technology, and that's why Liam Kerr's amendments were so helpful in this regard. The bill also prohibits public bodies from raising a defamation action. John Finney has just been outlining. It's vitally important that a public body such as local authorities, the Scottish Parliament, Scottish ministers, etc., should be open to public scrutiny and uninhibited criticism. But this is not because a public body doesn't have a reputation or is beyond scrutiny. It's because defamation law is not the appropriate way to defend that reputation. As the Minister said, this should be done at the ballot box. Private bodies, of course, can't do this, so it's only right that we don't prohibit them from raising defamation actions. But this doesn't mean the bill fails to protect those who criticise and scrutinise these companies. They'll be able to rely on the new defence of publication on a matter of public interest, the reformed defence of honest opinion and the serious harm threshold test to protect their legitimate speech. Presiding Officer, when someone suffers serious harm to their reputation, they usually should know this soon after a defamatory statement is published. This is why the bill reduces to 1 year the time limit in which legal action can be raised. In this day and age, it's no longer appropriate to have the limitation clock begin again each and every time an article is downloaded or accessed online. It's just not practical. We know that the current length of the limitation period can be used to chill freedom of expression, and we heard evidence of this during our scrutiny. It can be used to discourage investigative journalists where the fear or threat that defamation proceedings could be raised many years down the road, and that blocks free expression. It's not to say that the 1 year limit is absolute, because there is flexibility in the bill that can take into account any subsequent publication to disapply the time limit where to do so. So in conclusion, Presiding Officer, I warmly welcome this bill and commend everyone who had a part in shaping it. I believe it does strike the right balance between freedom of expression and protecting an individual reputation, and I urge the Chamber to pass it at stage 3. Thank you.
Thank you very much. We now move to closing speeches, and I call on James Kelly.
Thank you, Deputy Presiding Officer, and as others have done, can I thank the Justice Committee for the work that they've done in this bill. I'm very aware as a former member of the committee as to the workload that the Justice Committee has taken on in the recent period, particularly the hate crime legislation, and it's to their credit that we've been able to take this legislation through and make some improvements to it as it's moved to stage 3. I also think it's important to recognise the role of the Scottish Law Commission. They brought forward the report that showed the need for legislation in this area. As Liam MacArthur said, this will be seen by some as quite a technical bill. However, it's very, very much needed. The law needed to be made more up to date and modern. I think the changes that were made in England and Wales helpful in that legislature, and I think it was useful to learn from that experience. I think throughout the discussion on the bill, there's been this kind of two kind of pulling forces, if you like. It's clearly important to defend freedom of speech. However, that must be important not to campaign into an area where people are defamatory, and that is unacceptable, and there should be legal provisions in place to ensure that those who are defamed are able to take appropriate action in the courts. And I think what happened in terms of the government's progress with the bill and also the committee consideration of the bill is on the various issues they've kind of tussled with this freedom of speech versus not allowing people to defame. And I think broadly they've got it right. So for example, on issues like the serious harm test, the bill is drafted and then the changes that were made that ensures that the balance is correct on that. Although I do say that, I agree with Liam MacArthur in terms of changes that Andy Whiteman brought forward, I think would have brought further clarity to the law. As ever, Mr. Whiteman interacted, very kind of seriously with this legislation and with the committee. He brings a lot of experience to it, and he brings a lot of experience to other areas of legislation in the Parliament. And I don't want to put on record that he's a highly respected MSP across all parties. I think the changes that have been made, and one of the issues that was discussed through time was the right appropriate defences. And I think it is important to codify that in law, and allowing people to have a defence of honest opinion or the public interest was correct. I do share Neil Bibby's concern in relation to the Derbyshire principle that public bodies who operate in a charitable environment should have been subject to that principle, and it's regrettable that those changes weren't accepted at stage 2. However, in summing up, Deputy Presiding Officer, I think this piece of legislation adds to the toolkit, particularly in the social media age, of giving appropriate protection to people who are defamed, to ensure that it's easier as a result of this legislation to bring action through the courts. Thank you, Deputy Presiding Officer.
Thank you very much. I now call Adam Tompkins.
Thank you very much, Deputy Presiding Officer. So as we've heard, this bill, which originated in the work of the Scottish Law Commission, puts the Scots law of defamation on a statutory footing that really is fit for the 21st century. And in doing so, again, as we've heard, it addresses and balances two competing rights: the right to freedom of expression on the one hand, and the right to protect one's reputation, often seen as an aspect of the right to privacy, on the other. Taken as a whole, this bill gets that balance right. It does so by shifting, perhaps only subtly shifting, but nonetheless shifting the balance that we have in the current law. And the bill shifts the balance in favour of freedom of speech. So it says, for example, we debated this earlier this afternoon, that for a defamation action to succeed, a pursuer will have to show not merely harm, but serious harm to their reputation. And it says also that defamation actions will generally have to be commenced within 1 year rather than within the current 3-year period of the harm occurring. Now, some commentators have expressed concerns about this shift in favour of greater freedom of speech, but most have welcomed it. And in particular, and unsurprisingly, I suppose, media organisations have welcomed it strongly. It addresses the chilling effect, they have said, which the current law of defamation can sometimes cast over journalists, publishers and writers when actions are brought or indeed even threatened by pursuers. Now, I have to say, Presiding Officer, that I very much welcome this shift in favour of free speech. Free speech matters now as much as ever, and we can never take it for granted, and we must always be on our guard to protect it. It matters for democracy, it matters for anyone who cares about the truth, and it matters too, of course, for individual self-fulfilment and liberty. Free speech acts as a brake on the abuse of power by public officials. It facilitates the exposure of errors in government, and it is an essential condition of an intellectually healthy society. So I'm glad to support any bill that advances freedom of speech, however subtly as this bill does. And likewise, any bill that threatens free speech would be one I would want to scrutinise very carefully indeed. We may come back to some of these points next week, Presiding Officer, when we debate once again the notorious hate crime bill. And I'm not the only one this afternoon to have drawn parallels between the defamation bill and the hate crime bill. Now, because of the admirable work of the Law Commission, the defamation bill has not needed a great deal of amendment as it has progressed through its legislative stages. One area that was improved at stage 2 is the so-called Derbyshire principle, named after an English case decided by the House of Lords in the early 1990s. This is the principle, of course, that local authorities may not sue in defamation. If you are an elected official, the place where you seek to protect your reputation is in the ballot box, not in the defamation courts. As Lord Keith said in this case, and I quote, "It's of the highest public importance that a democratically elected governmental body, or indeed any governmental body, should be open to uninhibited public criticism," unquote. And the bill puts this principle, which is a judge-made rule of the common law, on a statutory footing. As originally drafted, there were some concerns about how this was proposed to be done in the bill. In particular, the question was whether private bodies that are carrying out functions of a public nature should also be barred, as local authorities are, from suing in defamation. And I'm pleased that this issue was fixed at stage 2 and indeed has not needed to be revisited at stage 3 this afternoon by incorporating into this bill the same basic approach to the question of the scope of public authorities that we find in the Human Rights Act. That's a good solution, it's a workable solution, and I think it will make sense in the context of this bill. Let me close, Presiding Officer, with this final point. Placing the modern law of defamation on a statutory footing should aid the accessibility of the law, but should in no sense freeze its ongoing development in the case law of the courts. The single most important and liberalising reform to defamation in recent years, the creation of the new Defence of Publication in the Public Interest in the Reynolds case, came, of course, in case law and not in statute. So I welcome this bill and I support it. I will support it at decision time this evening, and I do so in both the hope and the expectation that it will assist the courts as the law of defamation and malicious publication continues to be developed by them. This is a really good bill, Presiding Officer. It makes welcome and valuable changes to Scots law. And I thank the Law Commission, the Minister, and all my colleagues on the Justice Committee for all of their work on it. And I look forward to voting for this bill in a few minutes' time. Thank you.
Thank you very much. I now call on Ash Denham to wind up the debate. Generous 6 minutes, Minister.
Okay. Thank you, Presiding Officer. And I want to begin by thanking everyone today for their contribution to the debate. And I've listened to what's been said, and I welcome the general support that's been given across the Chamber for the aims of the bill. And in closing, I want to touch briefly on some of the provisions that we've discussed. So, reputation plays an important part in informing many of our day-to-day decisions. And so, in my view, it's helpful to have a simple and clear definition of what defamation is. The definition is a simple restatement, but in the modern language, of the common law test, which is now 85 years old. And it's a restatement of the current law and not a departure from it. Now, the serious harm threshold has been the subject of quite a bit of debate as this bill has progressed. I think it came up at stage 1, 2 and now at stage 3. Some say that it's a solution to a problem that doesn't exist in Scotland and it will deter legitimate claims. Measuring the issue on the number of cases, though, that proceed to court, I think is to miss the problem. And the possibility of litigation deters legitimate speech. And during evidence, a number of stakeholders gave, as examples, their direct experiences. And the law of defamation places a considerable burden on an author, on an editor or a publisher to defend what they have published. And if Parliament agrees, the serious harm test will shift part of that burden back towards the pursuer, who will, in relevant circumstances, have to prove a minimum level of damage to their reputation. And this is, to my mind, a more appropriate balance than the current law allows for. So, as mentioned by Liam Kerr and Neil Bibby in their contributions, importantly, it avoids that chilling effect that we've heard about through some of the submissions to the committee in the early stages of the bills proceeding through the Parliament. And the threshold of serious harm means that the people of Scotland will have the same level of protection for freedom of expression as those in England and Wales currently do. On the so-called Derbyshire principle, which came up this afternoon during the debate, John Finney, I note the comments that he made on this. The bill was, of course, amended at stage 2 to add additional clarity on the Derbyshire principle, and that was set out quite well, I think, by Adam Tompkins in his contribution this afternoon. Some people in the chamber have mentioned that private companies delivering public services should be prohibited from raising defamation actions. And this argument is because public authorities are prohibited, so should those companies who take public money. But public authorities are not prohibited from raising an action under this section because they are in charge of public money. They're prohibited because in a democratic system, the ballot box is the appropriate place for its reputation to be evaluated and, where appropriate, repaired. And a private company cannot use the ballot box to repair damage to its reputation. So we should not remove rights as currently enjoyed by a company or indeed by a charity, as was raised by Neil Bibby in his contribution, simply because it chooses to contract with a public authority. But this is not to say that the bill does not offer enhanced protections for those who wish to criticise the private delivery of public services. The bill sets out the threshold test of serious harm, as we've discussed, the defences of honest opinion and publication on a matter of public interest, and the reduced limitation period, as mentioned by Rona Mackay in her contribution this afternoon, and the single publication rule. And all of these provisions will in some way help. John Finney and Adam Tompkins also noted that delicate balancing act required between the two competing rights represented in the Articles 8 and Article 10. And I'm very pleased to hear this afternoon that the Parliament believes that the correct balance has been struck here. Other provisions that have been discussed and are worth mentioning in brief are provisions to encourage the use of alternative methods of dispute resolution, the wider range of remedies available to restore damaged reputation, and the provisions on malicious publication that are the result of the substantial work undertaken by the Scottish Law Commission. And I'd like to thank once again the Scottish Law Commission for the time and effort that it put into reviewing the current law of defamation and verbal injury, for its significant consultation work and for its final recommendation. And the bill, I think, is a reflection of those efforts. So defamation law in Scotland dates back for over 100 years. And the Scottish Law Commission noted two cases in its discussion paper, and that was the case of the Duke of Brunswick versus Harmer, and that was in 1849, which was the year that the Buchanan Street railway station was first opened. And another case of McKellar versus Duke of Sutherland, and that was in 1859. Then one of the leading cases in Scots law was Mackay versus McCankie, and that was in 1883. And that case held that the defamation can arise if an imputation is communicated merely to the person who is the subject of it. And around about that time, telephones were just starting to be used. The last time that the law was substantively updated was in 1996, and that is a year that I do remember. The internet was just getting going. It was in its early stages. I still didn't have a mobile phone. I obviously wasn't an early adopter. I got one for the first time a year later than that. There was no Facebook, there was no Twitter, and people, I remember, seemed to spend a lot of time sending faxes. With the development and widespread use of modern technology, defamation law now has the potential to impact a far greater number of people than even a generation ago. And it's no longer only the media who are likely to be affected. Individuals can now create content with their phone, and social media has fundamentally changed the way that we communicate with each other. The 21st century and the technological developments within it require us to respond to that changing nature of our communication. And so the bill creates a clear and accessible framework that reflects that reality of modern Scotland, introducing effective remedies for protecting reputation and stronger protections for freedom of expression. So, Presiding Officer, I commend the motion in my name.
Thank you very much. That concludes the debate on the Defamation and Malicious Publication Scotland Bill, and we will move on shortly to the next item of business.